Hello, welcome back to my channel. So today we will discuss sources and nature of the Constitution. That is topic number 1 of your Canadian Constitutional Law NC exam syllabus. So as we know, the Canadian Constitution does not emerge from a single document like the United States or India. The Canadian Constitution draws from a combination of written text, judicial decisions, conventions, and written principles. These sources are necessary to understand how Canadian constitutional law operates in practice. So, coming to the written sources, these include formal codified documents and statutes that provide the foundational legal structure of Canada. First, we will cover the Constitution Act 1867, formerly the British North American Act 1867. This act established Canada as a federal state, dividing powers between the federal government and the provinces. It laid out the framework for parliament, the judiciary, and the executive. Second is the Constitution Act 1982. This act includes the Canadian Charter of Rights and Freedoms and provisions for the amendment of the Constitution. Before 1982, any amendment to Canada's constitution had to be approved by the UK Parliament. In addition to this, Section 52 of the Constitution Act 1982 serves as the backbone of the constitutional supremacy in Canada, ensuring that all the laws comply with the highest legal authority, the Constitution itself. So, Section 52 applies to the entire Constitution of Canada, which includes the Constitution Acts of 1867 and 1982, the Canadian Charter of Rights and Freedoms, and other constitutional documents, statutes, and amendments. Now, coming to the unwritten sources. Unwritten sources is essential as they complement the written constitution and fill the gaps where explicit text is absent. These elements come from conventions, judicial decisions, and common law principles that have evolved over time. So, first we will discuss about the constitutional conventions. Constitutional conventions are basically the unwritten rules that govern the political and constitutional conduct in Canada. Although they are not legally enforceable in courts, they are essential for the functioning of the Canadian political system. Basically, they are practices or norms that have developed over time and are accepted as binding by the political actors. Say, for example, the Governor General of Canada has several powers granted to it by the Constitution Act 1867. However, by convention, the Governor General will only exercise these powers on the advice of the Cabinet or the Prime Minister. Now, coming to the unwritten constitutional principles, the Supreme Court of Canada has recognized several unwritten constitutional principles that form part of the constitutional framework. These principles are not explicitly outlined in the written constitution, but they guide the interpretation and application of the constitution. Now, coming to the rule of law is a cornerstone principle of Canada's constitutional order. It means that all the government action must be authorized by law and everyone is subject to the law, including government officials. The next unwritten principle is federalism. Federalism basically refers to the division of powers between the federal government and the provincial government. Although the division of powers is written in the Constitution Act 1867, federalism as guiding principle extends beyond the text and ensures the autonomy of provinces to legislate in their own areas of jurisdiction and a balance between national unity and regional diversity, allowing provinces to address their own specific needs and concerns while remaining part of the larger federation. The next unwritten principle is constitutionalism. The principle of constitutionalism asserts that all the government actions must comply with the Constitution. The government power is not absolute and is subject to legal constraints, and the constitutional supremacy, as expressed in Section 52 of the Constitution, means that Any law inconsistent with the Constitution is invalid. Now coming to democracy, that is the next unwritten principle. This principle of democracy underpins the entire structure of Canada's political system, and it ensures that government is accountable to the people who express their will through free and fair elections. Majority rule is balanced by the protection of minority rights, and democratic participation is encouraged, allowing citizens to engage in a political process and influence governance. Then the next unwritten principle is protection of minorities. The protection of minorities is an unwritten constitutional principle that recognizes the need to safeguard the rights and interests of minority groups in Canada. And this principle ensures the minority rights are respected and the linguistic and cultural minorities, such as French speaking Canadians and Indigenous people, are given constitutional protection through language rights and recognition of the Indigenous rights. If we talk about reference re-secession of Quebec 1998, the court relied heavily on unwritten principles such as federalism, democracy, rule of law, and the protection of minorities, highlighting that these principles are just as important as the written text of Constitution. Together, they form the foundation of Canada's constitutional structure, ensuring that even in the matters not explicitly addressed by the Constitution, the system operates in a way that respects the interest of all the Canadians and upholds fundamental values of fairness, legality, and cooperation. This case illustrates how the unwritten constitutional principles help interpret and fill the gap left by the written constitution, providing a framework for resolving complex constitutional issues. Now, coming to the next unwritten principle, that is judicial independence. This judicial independence ensures that the judiciary is free from interference from the executive and legislative branches of the government. This principle is vital for ensuring impartial decision making and protecting individuals' rights under the law. Next is parliamentary privilege. It is an unwritten constitutional principle that protects the rights and immunities of the members of parliament and provincial legislatures, allowing them to carry out their functions without interference from the courts or executive. It is essential for the effective functioning of the legislature in a democratic system. Now coming to the royal prerogatives. Royal prerogatives in Canadian constitutional law refer to the historical powers and privileges originally held by the Crown, but now largely exercised by the executive branch. Although not explicitly outlined in the Constitution Act 1867 or other constitutional statutes, royal prerogatives are recognized and enforced by the Canadian courts, and they cover areas like foreign affairs, defense, the appointment of ministers, issuing of passports, and the dissolution of the parliament. Last but not the least, the customs and historical practices also form a part of the unwritten constitution. These are long-standing practices followed by the political actors, institutions, and the government, and they help to ensure the stability and continuity of the Canadian constitutional system. All right, now let's wrap up the content of today's lecture by attempting some practice questions. So here are some MCQs. Please pause the video, read the questions, and then send the answer in the comment box. First question is, which of the following is a written source of Canadian Constitution? A. The Living Tree Doctrine. B. The Constitutional Conventions. C. The Constitution Act 1867. D. The Doctrine of Parliamentary Sovereignty. Second question, which of the following is an example of constitutional convention in Canada? A. The supremacy of the Constitution. B. The division of powers between federal and provincial governments. C. The appointment of the Governor General by the Prime Minister. D. The requirement of provincial approval for amendments. Now the third question is, the rule of law in Canada implies that A. The judiciary can override Parliament's decision. B. Everyone is subject to and equal before the law. C. The Constitution can be amended without provincial consent. D. Judges can create new laws based on moral reasoning. You can send the answers in the comment box. Now here comes some true and false questions. Mention whether the statement is true or false with explanation in the comment box. So the statement number 1 is, the Constitution of Canada is entirely codified in written documents. Please state whether the statement is true or false with explanation in the comment box. Second statement is, the royal prerogative is entirely ceremonial and no longer has any constitutional significance in Canada. Statement number 3 is, unwritten constitutional principles such as federalism and the rule of law are not enforceable by courts. So here are the answers for true and false. Answer for statement number 1. Statement number 1 is false because Canada's constitution includes both written elements, that is statutes and the charter, and unwritten elements, that is conventions, judicial interpretations, and principles. Statement number 2 is also false because the royal prerogative includes powers such as summoning and dissolving parliament, though these are exercised on the advice of elected officials. And statement number 3 is also false because the courts have recognized and enforced unwritten principles such as in reference re-secession of Quebec 1998. So this is all for today. For latest updates on study material, IRACs, and mock exercises of Canadian constitutional law, subscribe our YouTube channel and follow us at Instagram. The links are provided in the description box. Thanks for watching the video.